Yeah, and it makes sense when you think about you're inviting people to come in, and there is a reasonable expectation as a customer or someone who's frequenting businesses or public places that it will be held reasonably safe, and you're not really in a position to anticipate dangers that wouldn't be obvious to you.
Yeah. And so the Walmart example that we just gave, I mean, that seems pretty obvious. It's like, okay, if you have 10 or 20 people who have fell in that area before, then you definitely have notice and you definitely need to fix it. But then there's situations where it's not so obvious. Like, for example, if nobody, fell or slipped in a particular area, then the first person who falls in that area, I mean, can Walmart turn around and just say, hey, we never, like, we didn't know anybody would injure themselves there because nobody's ever fallen there before. So therefore, we can't be held liable. I mean, is that a viable defense?
Yeah, they'll definitely try that. And I think what the law has done, which we'll talk about when we talk about foreseeability as an alternative to notice, we'll talk about how there are the law now holds businesses to holds businesses accountable for anticipating certain dangers that would be foreseeable, that you would expect just in operating a certain type of business or in a certain type of way. So, well, yeah, I think
Yeah. And I think so for premises because it can be a little bit overwhelming because this is a little bit of a different area of law than like motor vehicle accidents, which is just like when you get rear-ended, that the person who rear ends you is liable. I mean, that's been pretty established. In premises liability law, you don't really have that straightforward fact pattern as often. So we need like certain rules that we can go back to and say, okay, what are the things that we know we need to establish in order to have a winning premises liability case? What would those be, Mallory?
yeah, so the things that we need to prove that there's a dangerous condition, that there was notice, or we'll talk about foreseeability as an alternative to notice.
Yeah, and so it's pretty simple. It's just two things. You need a dangerous condition, and then you need to either satisfy notice or foreseeability. It's
Right.
kind of like a two-prong test. And this is so important because a lot of times in pre-litigation, um, we'll send a demand package and they'll just deny liability. We won't have any evidence. Like for example, the Walmart example, they'll have video, but they don't have to give us video, in pre-litigation. So they have more information than we do. So a lot of times in premises liability, they just deny liability. So we need to file a lawsuit. And when we file a lawsuit, the first thing that comes from the defense is a summary judgment motion. And that summary judgment motion is essentially saying, Judge, this case can't even go forward, even if you say that all the facts are most favorable to the person bringing the claim or the injured person. Like, we can assume that whatever they say is true, you still can't win. And the reason they bring this motion, or the basis for bringing this motion, is either on dangerous condition or it's on the notice foreseeability, or
Right.
it's on both. And so we need to figure out how do we get over that hump? Because once we get over the summary judgment hump in litigation, we'll get a settlement offer. That's almost a guarantee. And that's essentially what we're trying to do in these cases is we're trying to get over the summary judgment hump. And so